My name is Nyaundi. I hold a PhD in Public International Law from the University of Cape Town in South Africa. Engaged in legal consultancy and corporate practice. BBI was a creation of what became commonly and popularly known as the handshake between former President Uhuru Kenyatta and former Prime Minister Raila Odinga. The agreement they reached had a 9-point agenda that was going to be translated into law under the Constitution had the BBI passed as an amendment to the Constitution. It was introduced under as an amendment to the Constitution under Article 257. That is an amendment by popular initiative. It was passed in a breakneck speed through the 25 counties that the Constitution requires. It was brought before Parliament, whereupon it was attacked by citizens. Many of them filed constitutional petitions in the High Court to question the constitutionality of that process. And the issue that was prominent in that question were really just 3 questions. Number 1, the question was, could the president introduce an amendment to the Constitution through a popular initiative path? There are only 2 pathways to constitutional amendment. That is under Article 256 through a parliamentary initiative, or 257 through a popular initiative. In its very elaborate analysis of that choice of amendment pathway, the Supreme Court said no, the president as president cannot introduce a constitutional amendment which is reserved for the common man. Objection was taken on the fact that the constitutional amendment bill had not been subjected to sufficient public participation. In other words, the amendments that were being sought to be introduced to the Constitution had not been explained to the population. And then, of course, the fact that the IEBC was not well established to run the referendum that would have preceded the constitutional amendment. To address the issue of unequal representation, BBI sought to introduce another 70 constituencies. The creation of the 70 constituencies in the constitutional amendment bill was observed by the Supreme Court to be a direction given by Parliament to a constitutional body whose mandate it is to decide on the placing of those constituencies, and that is the Electoral Commission. When you look at the Supreme Court ruling, BBI failed on technical aspects, not because what it sought to introduce were negatives. The other thing that maybe one would say informed the attitude that the Supreme Court took was that BBI sought to introduce the position of a judiciary ombudsman, an appointee of the executive who would supervise the judiciary. One would say this: the judiciary is not acting absent of the law or the Constitution, because Article 259 of our Constitution mandates the judiciary to interpret the Constitution in a manner that promotes its principles, values, and purpose. Issues as to whether the Kenyan Constitution has got a basic structure that cannot be, that there are certain provisions in the Constitution that cannot be amended, was found by the Supreme Court to be wanting, because those provisions that need to be taken through a referendum are set out in Article 255. And also, speaking for myself, the basic structure as held in the High Court and the Court of Appeal that introduced the judiciary into an amendment process, which the Constitution does not. The amendment provisions in the Constitution do not foresee the participation of the judiciary in an amendment. That is a basic legislative function. What comes out in this country now and on the continent, the constitutional developments have now strengthened the hand of the citizen to be a major stakeholder in social developments as guided by the Constitution. In many parts of the continent, the executive now has been taken by the citizen, not by their own free will, have been forced to a path where they have to obey their constitutions.